Good afternoon, friends. So, today I'm going to discuss this rather off-beat topic about whether animal sacrifice is constitutionally protected and whether this is part of the practice which can have a constitutional protection. The reason I am discussing this is because you might have read in the newspapers and the various social media platforms that right now in Calcutta High Court, a PIL was filed wherein the challenge was to a practice of sacrifice of goat and buffaloes before Ma Kali. In not only in West Bengal but in various parts of India, we know that this animal sacrifice takes place in Devi temples. It happens in the temple of the main temple of the Guwahati, Assam. And there are various temples across the country where this practice of animal sacrifice happens. So I felt that we need to discuss whether what is protected by the constitution. So it is with that objective in mind that I'm discussing today, not that particular practice or what is happening in a particular temple that I want to discuss. So there is Article 25 of the Constitution, which guarantees freedom of conscience and free profession, practice and propagation of religion. Now, this freedom is subject to public order, public morality, and public health. And the lawmakers or the state has the power to make any law to regulate or restrict any economical, financial, political, or other secular activity which may be associated with the religious practice, and provide for social welfare and reform, and throw open of Hindu religious institution of a public character to all classes and sections of Hindus. So it is only, the constitution only grants the power with respect to Hindi religious institution to that the law can be made for reform or the social welfare. But you see, all this is subject to that the question then arises as to what is protected. So what is it that the constitution protects? So while you see the lawmakers have the power to regulate, restrict, or any economical, financial, political, or other secular activity, and the lawmaker also has the power to provide for the welfare and reform of any religious institution, then what it is that is protected? So there are various Supreme Court judgment as to what really is protected by Article 25. And it says that what is protected by the Constitution is a guarantee for rituals, observances, ceremonies, and modes of worship which are essential or integral part of the religion. So if any ritual or any ceremony or mode of worship or practice is there, which can be considered as essential or integral part of religion, then that essential part of religion has the constitutional protection. So the Constitution protects, Article 25 of the Constitution protects any doctrine, practices, tenets, or the historical background of any religion, but what it does not protect. So, Honorable Supreme Court has laid down some tests to, you see, it is very difficult for the court to say as to what practice is protected and what is not. Only when a particular practice is challenged before the court, then only the court can look into the question whether it is a essential part of the religion or not, and to test that whether a particular practice, because you see, as I have stated, any ritual, practice, ceremony, or mode of worship, or any doctrine has a protection. Then the question arises whether this animal sacrifice is a practice which is a essential part of the religion or not, or say any practice. There may be various kind of practices which goes on which we may not like, and one may challenge that particular practice in the court of law, because ultimately the Supreme Court has also said that the court is the final arbiter of any practice to determine whether it is a essential religious practice or not. So what are the tests? So the test to determine whether a part or practice is essential to a religion is to find out whether the nature of religion will be changed without that part or practice. If any part or practice is taken away and it changes the fundamental character of the religion or its belief, then such part could be treated as an essential or integral part of that religion, and there cannot be an addition or subtraction of such part, because it is the very essence of that religion, and alteration will change its fundamental character. So it is only such permanent essential parts which are protected by the Constitution. But the Supreme Court makes a very interesting observation that nobody can say that essential part or practice of one's religion has changed from a particular date or by an event. So, to determine whether a practice is a essential religious practice, the court can also look into how old is that practice, whether it is an age-old practice, whether it is from time immemorial, or whether it has come as a practice of religion in the recent times, and whether it is due to some superstitious belief. Now, there is another protection also in the Constitution, that is by virtue of Article 26. Now, Article 26 grants protection to every religious denomination, subject to, again, public order, morality, and public health. So, can one say that in a temple, if an animal sacrifice is happening, then that has the protection of the Article 26, because it falls within the purview of the religious denomination, and therefore, if a temple has a particular practice, then it should have the protection of Article 26. Now, again, what is a religious denomination? That has again been defined by the Honorable Supreme Court, which says that a religious denomination means that it must be a collection of individuals who have a system of beliefs or doctrines which they regard as conducive to their spiritual well-being. That is a common faith. Then common organization and designation by a distinctive name. Then Supreme Court goes on to give an illustration of what can be considered as religious denomination, and says that it is well known that the practice of setting of mutts as centers of theological teaching was started by Sri Sankaracharya and followed by various teachers since then. After Sankaracharya came a galaxy of religious leaders and philosophers who founded the different sects and subsects of the Hindu religion that we find in India at the present. Each one of such sects or subsects can certainly be called a religious denomination as it is designated by a distinctive name, and in many cases it is the name of the founder, and has a common faith and common spiritual organization. But again, the religious denomination also will have to have the same level of protection or the lack of it as it is given by Article 25. So a religious denomination cannot claim a practice to be their individual practice and claim protection under 26, because it is a practice which is followed by them. Ultimately, one has to look into whether whatever practice they are following is an essential religious practice or not. Because what essentially is protected to a religious denomination is the right to establish and maintain institution for religious and charitable purpose, to manage their affair in the matters of religion, to own and acquire movable immovable property, and to administer such property in accordance with law. So it is with these purposes that a religious denomination has special rights, that they can own a property, they can administer such property, they can manage their affair with respect to the religion in their own way, and they can maintain and establish institution for such purposes. But they cannot say that we'll have our own practice, which is not a essential religious practice under Article 25, and claim special protection under Article 26. So, with respect to now, coming back to the question of animal sacrifice, there have been several judgments of Honorable Tripura that with respect to the animal sacrifice issue, there is a judgment of the Honorable Tripura High Court, judgment of Honorable Himachal Pradesh High Court, judgment of Honorable Uttarakhand High Court, which have held in various judgments that uh, animal sacrifice is not an essential religious practice. In this context, all these judgments are still pending with the Honorable Supreme Court, and the Supreme Court will have a final word on whether animal sacrifice is an essential religious practice or not. But in the meanwhile, uh, the Honorable Supreme Court had founded a committee to look into the various aspects of the animal welfare. So it was more in the context of the animal welfare rather than in the context of sacrifice. The issue of animal sacrifice is yet to have the final word of the Supreme Court. But a committee was formed for the purpose of formulation of various rules and regulation to ensure uh, the welfare of the animal under the animal welfare laws. And in that context, the committee gave various recommendations, and those recommendations were accepted by the Honorable Supreme Court, and the Honorable Supreme Court directed all state government to submit compliance report of the recommendation. And this is a judgment of dated 13/7/2015. And it was also directed that the compliance record shall be verified by the Secretary of the Animal Welfare Division, Ministry of Environment and Forest, within a particular time frame. Now, in this particular judgment, uh, they looked into the sacrifice, which was a 250-year-old practice, which used to happen at the Gandhi Mai festival in a Nepalese village near the Nepal-Bihar border, where mass sacrifice of the animals used to take place in that Gandhi Mai Mela. Now, in that context, this committee said that the main problem of sacrificing cattle at the Gandhi Mai festival lies in the superstition which is associated with the fulfillment of wishes. And therefore, this committee said that there is a need to create awareness regarding the superstition and belief by organizing camps for educating the people through educational films, documentaries, or through performing arts to convey a befitting message. So this committee has said that these kind of practices are superstitious beliefs. And Honorable Supreme Court has said time and again that what is protected is the essential religious practice without which a religion will not be religion and its fundamental character will change if that practice is disowned. But what is not protected is superstitious belief. So the superstitious beliefs which creeps into as a practice of a religion from time to time, that does not enjoy the protection of the constitution. So now I will not, since the Supreme Court is yet to have the final word on whether a sacrifice is a essential religious practice or not. So, and I myself, I'm not a person who has the expertise or the wisdom to be able to conclusively say whether this practice is a essential religious practice or not, or whether the Hindu dharma will change if this practice is disbanded. But before I conclude, I would like to refer a few paragraphs from a judgment of the Honorable Supreme Court, which was delivered in the context of whether the archakas, that is the priest who used to perform religious practices in the Tirumala temple, whether only those who had the heredity of the priest when the temple was set up, only they have the right, or whether the government of the Andhra Pradesh has the right to formulate a law to regulate the appointment of the priest or the archika. So Honorable Supreme Court in that context says that what is protected by Article 25 is the tenets, agamas, customs and usages prevalent in the temple, as they are integral part of the religious faith and belief. And to that extent, legislature cannot intervene to regulate it. But the service of priest is a secular part. And therefore, right to perform religious service has the appointment by the owner of the temple or king as it shows. The legislature is competent to enact law by taking away the hereditary right to succeed to an office in temple and equally to the office of the priest. So, in this particular judgment, the Honorable Supreme Court tried to uh, refer to what is the meaning of the religion, what is the meaning of the dharma and all that. And I would like to refer to few paragraphs with respect to what the Honorable Supreme Court referred to as the dharma. And of course, it referred from the various religious textbook by Vivekananda and other uh, religious gurus who have authored authoritative books on the various aspects and facets of the religion and dharma. And Honorable Supreme Court says that according to Hindu belief, worship of God is of four kinds. Japa, that is chanting mantras or slokas. Ashtaka Sara, Homa, that is giving oblation into the fire. Archana, worship of God in the form of idol in a temple. And Dhyana, that is concentration on God alone. Further, the Honorable Supreme Court said that the dharma is different from religion. Supreme Court said that dharma embraces every kind of righteous conduct, covering every aspect of life essential for sustenance and welfare of the individual and the society, and includes those rules which guide and enable those who believe in God and heaven to attain moksha. Rules of dharma are meant to regulate the individual conduct in such a way as to restrict the rights, liberty, interest, and desires of an individual as regards all matters to the extent necessary in the interest of other individual, that is the society, and at the same time making it obligatory for the society to safeguard and protect the individual in all respect through its social and political institution. So shortly put, dharma regulates the mutual obligation of individual and society. And a state of dharma was required to be always maintained for peaceful coexistence and prosperity of all. So we should keep in mind that the religion and dharma is not the one and same thing. Dharma is performance of one's righteous manner in conducting oneself with the society and doing all that which is necessary to protect the interest of all and respect one who adheres to the dharma. So the dharma constitutes the foundation of all affairs in the world. And dharma insulates a man against sinful thoughts and action. And everything in this world is founded on dharma. And dharma is considered to be supreme. But a religious practices, they are not, they are distinct from dharma, and religious practices which are considered to be essential religious practice is protected by the constitution by virtue of article 25. Now whether the animal sacrifice is a essential religious practice or not, I hope that the viewers will enlighten me with their thoughts on this particular issue, and so that that particular knowledge we can use to help this particular barbaric practice be stopped, not only in West Bengal but all across India. Because I personally believe that sacrificing an animal for the performance of any kind of a puja before the god or goddesses cannot be or should not be considered as an essential religious practice. Thank you very much.